Hello and welcome to Vienna Arbitration Talks. This week, Vienna has been the setting of a very important event for international arbitration and international trade in general, the resumed 38th session of Working Group III of the United Nations Commission for International Trade Law, or in short, UNCITRAL. As you may know, the Working Group III is in the midst of groundbreaking deliberations on the possible reform of investor-state dispute settlement, or in short, ISDS. And we're very lucky to have the unique opportunity to host here with us today, straight from the working group, the chairman of the working group, Shane Spelliscy. Hi, Shane, and welcome to Vienna.
Hi, Peter. Thanks for having me.
Shane has come here straight from the Vienna headquarters of the United Nations, where the session has just been concluded about an hour ago. But before turning to the developments in the working group, let's talk about Shane's day-to-day work in Ottawa, where he's based. When he's not in Vienna or New York acting as the chairman of the working group, he works for the Canadian federal government. He is the director and general counsel of the Investment and Services Division of the Trade Law Bureau. So, Shane, you're the main representative of Canada in disputes under Canada's investment treaties. And your department provides legal advice to the Canadian government in negotiating new investment treaties. And you also provide legal advice on Canada's obligation on existing treaties, right? So if we talk about your role with the Canadian government first, we recently hosted Jeremy Sharp in our show, and he was telling us how representation in investment arbitration is organized in the US. Could you tell us how things are done in Canada?
Sure, I'd be happy to. We organize ourselves a little bit differently than the United States does. So as you mentioned, the Trade Law Bureau, which was founded about 26 years ago, is responsible for the three facets of Canada's trade legal representation. It's the actual representation in disputes, it's the legal advice, as well as the treaty negotiations. So whereas the US separates its litigators from its treaty negotiators, Canada made the decision to actually have those people do both, out of a desire to have us see not just the litigation side of it, but actually how the treaties are made, and a feeling that that was an important bit of knowledge for people doing disputes to actually have, to see what it is that the treaties, how they're formed, what the obligations are, how the negotiations occur. So we try to make sure that for any of my lawyers that are in the group, they do not only disputes, but they actually do negotiations as well. And this was, as I say, a decision made about 25 years ago when the Trade Law Bureau was created through a special agreement, it's one of the only ones in the Canadian government, between the Department of Justice and Global Affairs Canada to create this special department that would do exclusively trade law and would be Canada's lead department on trade law.
Oh, thank you. Let's turn to our main topic for the day then, the deliberations of working group and the possible reform of ISDS. Could you tell us more about the working group? Who are the delegates? What is the mandate?
So one of the great advantages of UNCITRAL is that it can operate an open and very transparent process. The delegates are mostly representatives of states, so I think this week we had about 110 states, maybe slightly a little bit less there, and they were represented by individuals either who work for the government or who are external counsel that have been hired. But for the most part, these are actual government officials. We've been lucky in UNCITRAL Working Group III, where we've asked governments right at the very beginning to ensure that the appropriate government officials came. And so what we have is a lot of the litigators for governments, people doing the disputes for governments, much like I do for the Government of Canada, as well as people who negotiate the treaties. In addition, there are international governmental organizations that attend. So you have from sister UN organizations like UNCTAD to ICSID, from the World Bank to a number of other intergovernmental bodies, as well as you have non-governmental organizations. And I would say that that spreads the range from more business-focused organizations to arbitral institutions, to environmental groups and international environmental groups, to international labor organizations, and even representatives of unions. So one of the advantages that that gives us in the working group is the ability to hear a broad perspective from all states. So UNCITRAL, even though it has 60 member states directly, it's open in the deliberations to all views. And so when I'm on the chair and as I recognize different delegations, I recognize delegations in the order in which we see them. And so if that means recognizing a state to provide us one view and recognizing an international environmental organization next, that is the way that it goes. The only difference that ever occurs is if we are running out of time. And if we are running out of time, we do tend to take states first, And when I say states first, it doesn't matter whether you're a member of the organization or whether you're an observer of the organization. We treat all governments the same. The only difference comes if there was ever a vote. And hopefully we won't ever get there.
That's a very wide participation in this working group. You said 110 states are present, and there's only 60 member states in UNCITRAL, so that's quite a big working group.
It is a big working group. In fact, one of the most attended working groups in UNCITRAL. There were over 400 people, 400 individual delegates that were here, and the numbers do vary as well. It can increase in New York, where there are even bigger facilities. It has posed some logistical problems. The size of the room available in Vienna.
Is there a breakout room now?
There is a breakout room, and that's where I'm sure all the fun is had, because we can't see them on the screens. But there is a breakout room where the additional delegates can sit. So generally the rule is that there will be a place for one delegate for each delegation in front of the microphone. If there is a state, it may have a spot for one or two other delegates to sit behind. But that would be it. And so some delegations now are coming with 5 or 6 different representatives to cover the breadth of the topics we are discussing. And many of them have to go sit in the breakout room. In New York, we have an advantage that it is bigger rooms. There are larger facilities in New York, and we can generally fit everybody in one room. Although the challenge there is many of the delegations are so far back and so high that it can be actually difficult for me to see who they are when they raise their flag. It is almost stadium-style seating.
The session has just been concluded, and the delegates are, I guess, on their way home. Could you tell us what has been discussed this week?
We had a packed agenda this week. We were talking about 3 major topics. One would be an appeals mechanism for international investment dispute settlement. The other was a multilateral investment court as a permanent mechanism. And the third was a broader topic of selection of adjudicators. But we obviously had to break down the topics a little bit more than that. Those are big topics. It's hard to get a room full of 400 people to actually engage on big topics. So we tried to be a little more specific. So for appeals mechanism, for example, we talked about that in the context of a permanent appeals mechanism, a standing body that would be standalone, that would be independent. We talked about it in the context of a second tier of a multilateral investment court. And we also talked about it in the context maybe of an ad hoc mechanism. We talked about technical issues, including the scope of appeal, the standard of review, the effect of appeal, meaning whether it would be considered binding. Is it stare decisis? Is it precedent? What would be the impact on other tribunals? What would be the impact as well on as persuasive authority?
And also under other treaties, I would imagine.
Under other treaties as well. And one of the issues in investment arbitration is, of course, many of the treaties have very similar language. In Canada's practice, we've had sort of 3 variations of models that have come out, where we had an early model, which was more on the OECD style based. We had a NAFTA based model, and then we've had a model since 2004. And in our treaties, there's not a lot of variation as we sign pursuant to those models. So you often have treaties with different countries. Each treaty negotiation is unique. Small differences will exist, but many of the provisions are relatively similar. Now, under international law, that doesn't mean they necessarily have to be interpreted in the same way. Of course, you have to look under the Vienna Convention to understand what the history of the negotiations were, what was the intent of the party. But it is a fact that there is discussion in the working group about the effect that decisions of an appellate body might have on treaties of states who are not potentially members of the appellate body.
And about the effect of appeal, you've mentioned the effect of appeal. What would this body be able to do? I guess it's a bit more complicated to remand the trial.
Certainly, there was generally a widely held view that the new body should certainly be able to affirm, reverse, or modify. The question of remand was a little more tricky because, as you say, there are some differences in how that might work if it was a permanent institution or if it was ad hoc first instance tribunals. So in the case of a permanent institution, remand becomes a little easier. In the case of ad hoc tribunals, remand was still considered as a possibility. But there were discussions of the pros and cons of remand in the working group as well, with some delegations looking for a broad power of remand, some delegations concerned that a broad power of remand would lead to it happening in almost every case, which would increase cost and duration. Other delegations suggesting that, in fact, if we have a more limited power of remand, maybe only where necessary because the appellate body doesn't have the facts before it that are necessary to decide the dispute itself, it could find a balance. And so there are all those three options available in terms of remand and how it might work.
What was said about grounds for appeal in these cases about questions of law, questions of fact?
So the scope of review was certainly one of the first things that we discussed about what a new appeals body would be. This is one of the core issues that one would consider in setting up an appellate mechanism. Views on this were varied amongst delegations as well. Some delegations felt that this should be only de novo review of questions of law. Some delegations felt it should be a review of questions of law, but actually not every question of law, only if there were serious errors of law. Others felt that that might work to ensure better consistency, but that it wouldn't really address the problem that they felt about correctness, because the correctness was often an issue in the application of the law to the facts or in the consideration of the facts itself. So they were more interested in seeing an appeal also consider facts. But of course, there is a concern about cost and duration. And so the most generally held view was that if there was going to be a review of questions of fact, that it should focus more on what were termed manifest errors in fact. That, of course, leaves some questions as well that the working group will still have to struggle with. What exactly is a manifest error of fact? How manifest does it have to be, and what does that term mean? And also, we set for future work the question of, well, where does the application of the law to the facts come in? Is that a question of fact? Which standard would it be subject to? So I would say that in terms of scope of review, there wasn't much doubt that questions of law should be considered. There was more doubt and more questioning of whether fact should be considered, but right now we still have all options on the table.
I understand there was talk about the Multilateral Standing Investment Court. You said something about this before. What was said about this?
So in a sense, we were talking about the Multilateral Investment Court as well when we're talking about an appeal mechanism, because any conception of a multilateral investment court has two tiers in it, a first instance and a second instance. And so our discussions in that sense covered both aspects. We did talk specifically about the financing and the enforcement of decisions from permanent structures, and that would include a new permanent multilateral investment court, as well as potentially a permanent standalone mechanism. So the questions were really, how would the decisions of such mechanisms be enforced? Could they be enforced under existing conventions that are like the ICSID Convention and the New York Convention? Would we need a new convention? Should we have a new convention anyways on enforcement? And questions on financing came to, well, how would we actually, if they're setting up new mechanisms, fund these mechanisms? Would it be through member state fees? Would it be through user fees? Or would it be through some sort of hybrid mechanism that considered both?
So about, you've mentioned enforcement. I guess there shouldn't be too much of a problem in enforcing under the New York Convention in the case of an ad hoc appeals mechanism, right? Or
certainly that view was expressed, that in the case of an ad hoc appeals mechanism that maintained many of the features of arbitration, that enforcement should be possible under the New York Convention.
I mean, there is a question whether it is or not, but I guess it's easier than in the case of a standing court, no?
Yeah, there were some different views were expressed on that. I think some delegations felt that that was the case. Other delegations felt that even in the case of a standing mechanism, if it was reviewing appellate decisions, that it still could be enforced under the New York Convention. And I think we heard interventions including from academic groups who form up a big part of UNCITRAL as well, that there was disagreement amongst legal academics and scholars on this. And I didn't mention the academic groups earlier, but there is an academic forum that supports UNCITRAL, as well as a practitioners forum that supports us in our work and provides advice and guidance.
So you've mentioned, you've spoken about selection of and appointment of ISDS tribunal members. As we know, the existing system has been criticized. There have been things have been said about repeat appointments, about the practice of switching roles between counsel, arbitrator, and experts. Now, parties in proceedings right now, investors and state, have quite a broad discretion in whom they wish to appoint. I understand that the working group is looking into reform of this as well.
We are certainly looking at it. I think one thing that was clear from the working group this week was that delegations recognize that the question of appointment is one of the core questions to consider in this action. Many delegations emphasized that the whole system was really only as strong as the legitimacy, the competence, the independence and impartiality of the arbitrators or adjudicators who decided the cases before them. In terms of the criticism, yes. I mean, one of the reasons that we are here has been a fairly vociferous criticism of the system of party-appointed ad hoc arbitration. There are mixed views on that in the working group. I think that a number of delegations still feel that party appointment is key and that it is one of the features of the system that gives it its legitimacy, including particularly to the business community who feel it's important, but also to states who, a number of states emphasize the importance of their ability to appoint. In this regard, I look at a number of delegations who have various views and diverse views on the continued role of party appointment, and certainly many options were considered. I would say even those delegations that are interested in maintaining the role of party appointment recognize that reform is required. They just believe that party appointment can be maintained in the context of adopting other types of reform, such as code of conduct that would prohibit or potentially regulate practices like double hatting, or having potentially a roster system to provide for greater qualifications. I'd say the other thing that has received significant criticism in the terms of party appointment now is the lack of diversity in the existing mechanism, the lack of diversity on tribunals.
So under the current system, I guess it's up to the states and the investors, or then the tribunals together, to decide whom they wish to appoint. And I mean, the diversity right now is not ideal. I guess if there is a standing system, there should be some sort of formula on how to put people on these rosters. And
that's certainly on the table as one of the mechanisms to consider. When we talk about diversity, there's a lot of concern about diversity in numerous different senses, and that was one of the most interesting things that came out of this week, I think, was the breadth with which people understand the term diversity. We heard about not just gender diversity and cultural and geographic and regional, but other things like legal system diversity, developmental diversity in terms of level of development of countries, age diversity, social and cultural, all those factors playing into it, with a recognition by many of the delegates there that having a more diverse tribunal will in fact lead to better decision making. But then the question is, well, how do you take maybe qualifications and bring them into force and actually get diverse tribunals? Because it's one thing to write it into something as a suggestion or hortatory obligation or hortatory desire to achieve, but the reality is that if you don't get it on tribunals, it won't be effective. So we spent a lot of time actually speaking about that, I would say, today, starting yesterday afternoon and all of today, talking about one thing in the selection of arbitrators: how would we achieve diversity? There are those who say that it can be achieved most effectively through the establishment of a permanent tribunal, which has rules and a statute which would enshrine and require certain obligations of diversity. There are others, though, who will say that that might get you some aspects of diversity, but the reality is it won't get you every aspect of diversity that we might want in cases where there is different legal systems at play, where there is different countries at play, where linguistic issues might matter, and that a system of party appointment, which allows far more flexibility, is a better way to achieve diversity because it really does open it up. They're interested in potentially including in treaties or in potentially a multilateral treaty on reform provisions that would either promote diversity in terms of all the types we talked about, or actually require it, subject to some penalties if it's actually not met.
the working group seems to have a lot of issues on its plate right now. I guess the work is still going to be going on for a while. I wanted to ask you, once the working group decides on what to do, on how the new system should look like, what can the working group do? What legal tools are available to UNCITRAL to achieve this?
UNCITRAL has a great degree of flexibility in the legal tools that it can actually produce, and I've seen that over the years that I've been working with it. UNCITRAL can produce model clauses that states could use to put in their own individual treaties. UNCITRAL could produce one of the items discussed on the agenda for next week in April, but was discussed at side events this week. UNCITRAL could produce a multilateral treaty that would cover issues of reform. And the way that treaty would work would be much like how the Mauritius Convention works, or even the BEPS Convention from the OECD works, which is it is a multilateral treaty that could be used to add or amend existing bilateral treaties once it's signed by both parties. So it's got other soft law instruments at its disposal as well. You could have guidance documents. You could have soft law guides for tribunals, guides for states. It could compose, for example, a roster of qualified individuals, which was non-binding, and keep a database of qualifications of those individuals that states could review and use. So one of the nice things when I talked about the transparency of UNCITRAL, another thing is its flexibility. Ultimately, whatever UNCITRAL produces has to be adopted in the sovereign decisions of states itself. UNCITRAL is not a treaty negotiation in the same way that it might be if you and I were countries in negotiating a bilateral treaty. We're expected to sign and ratify at the end. The way UNCITRAL works is it will produce a product, a recommendation, that will go up to the General Assembly. The General Assembly will then make some recommendations as to how to implement it, but then it will be up to states to decide how they actually implement it. So one can imagine, and you've seen this actually with the UNCITRAL rules on transparency in the Mauritius Convention, some states might use the UNCITRAL rules on transparency expressly in their treaties. Some states might use the rules and ratify the Mauritius Convention as Canada has done. And some states may take a look at that and treat the UNCITRAL rules on transparency more as model clauses to insert into their own treaty subject to negotiation as to what they're interested in.
You've mentioned the Mauritius Convention, and Canada was one of the first countries to ratify it. There is still not a lot of countries that have ratified it. Why do you think that is, and how come Canada was so fast in ratifying it?
Canada's always been one of the biggest proponents of transparency in investor-state dispute settlement. This policy started back in the early 2000s with NAFTA, and we were heavily involved in actually getting the project in front of the UNCITRAL Working Group itself. I remember one of my first jobs when I joined the government from the private practice was to actually submit a white paper to UNCITRAL arguing that transparency should be increased in investor-state arbitration because current modes of confidential dispute resolution really didn't sit well with how investor-state arbitration works. In investor-state arbitration, it's public money, it's public measures, it's government conduct. This is stuff the public has a right to know about. So we've always been a big proponent of transparency. Right from the work in the UNCITRAL rules on transparency, where we were one of the leading delegations to the development of the Mauritius Convention. And so when the Mauritius Convention was available, we became one of the first to ratify it because we think it's important. I think in terms of the pace of ratification, we would certainly love for it to go faster. And we're in the process of communicating with partner governments and other governments who we have treaties with that are older and that the Mauritius Convention would apply to encourage them to sign the treaty. I think it's difficult to read too much into the pace of ratification. Some treaties take longer to ratify. One has to remember government processes. In order to get a treaty ratified, you have to get it on the agenda of the cabinet or the Senate or whatever it is. Governments have many, many things on the agenda, and even for a country like Canada, who places a great importance on transparency, there can be other pressing matters that come up that might be considered more urgent by the government, and you might be on a cabinet agenda and then bumped off. I think it's also, you have to be cautious about how you view the lack of ratifications. It doesn't mean there's a lack of support for transparency. Many of Canada's treaty partners in the past already have treaties with Canada that have transparency provisions. And so one of the challenges has been, if we want to increase ratification of the Mauritius Convention, is they say we already have these provisions. It doesn't mean that they're not supportive of the convention, particularly with respect to older treaties. But they look at it and say, well, what's the real need? Particularly one has to remember as well, we heard today that while there are over over the past week, there are over 3,000 treaties. There have only ever been 190 that have been interpreted, and right to the end. Around 400 was a number that have been first initiated in a dispute. The dispute was brought under that treaty, but only 190 in the end. There are many partner governments that Canada is in treaties with, where there's never been a dispute under our agreements. In fact, all of Canada's disputes up until recently were in fact under the NAFTA. We have had a few disputes brought since then under some of our FIPAs. But most governments look at it and say, is this a priority for us? We've had very few disputes under these agreements. Some of our more modern ones already have these provisions. And so I think that, speculating that might be some of the reason. But I don't read that lack of ratification as actually antipathy towards transparency. I think one of the things we've heard even this week when we talk about different processes is governments putting an emphasis on transparency. Exactly. Whether it's in dispute settlement or in the appointment processes, governments recognize that for a system to be legitimate, there has to be transparency for the public.
Yeah, I think we actually said this on the show already, but if there are state representatives watching, do ratify the Mauritius Convention. Thank you very much, Shane, for coming here today. I imagine it was a very exhausting week at the working group, and you're here on a Friday evening. Good luck and the best of success for the upcoming meetings of the working group. I hope we can host you soon again and you can tell us about the new developments. So, dear viewers, that is all for tonight. If you want to follow the developments of the working group more closely, the next session is going to be in New York in late March and early April, and you can download all working group papers and reports at the UNCITRAL website. So if you'd like to be notified about our new video, then please subscribe to our YouTube channel, Konrad Partners International Arbitration, and follow our hashtag Vienna Arbitration Talks. Thanks for watching and greetings from Vienna.